Welcome to Wallack's webinar, 1 year later, things to consider before reopening amenities at your community association. My name is Caroline Record, and I will be the moderator today. And we have 5 terrific panelists who will be giving all of us a lot of information on the amenity issues. A few housekeeping rules before we start. Please put any questions you have into the Q&A. We won't take questions during the presentations, but have left enough, quite a bit of time at the end in order to answer as many questions as we can. And we are, next slide, please. We do have a disclaimer, as lawyers typically do, that the information provided in this webinar today is not intended to constitute legal advice. It's for informational purposes only. We encourage you at all times to consult with your association attorney to obtain advice with respect to any particular legal matter. You should never act or refrain from acting on the basis of information provided in this program or any other without first seeking legal advice from the counsel for your association. So we hope you will heed this, and we're going to start right now with our first polling question. And we're asking you to take a few seconds now and give us a response to this question. Thank you. This webinar is being recorded, and some or all of it, we hope all of it will be available through our website in the near future. The results of the poll are that 49% of those attending thus far are community managers or management professionals, 44% are board members, 4% are owners, and 2 are others. So thank you very much for responding. Without further ado, we're going to turn to our first presenter, George Greatrex, who's in the Cherry Hill office. We're in 3 different locations today. And he's going to talk about one size doesn't fit all, different considerations and timing for different types of amenities. George?
George, you have to unmute.
Let me start over again and say thank you, Caroline. Good afternoon, everybody. Thanks so much for being here. We do have a lot to cover, so why don't we get right to it. So when addressing the question of whether to open your association's amenities during this state of emergency for COVID-19, we have to focus on 2 things. The first being how to minimize the community spread of the virus among our residents. And second is to how to minimize the association's liability in the event a person becomes infected and claims that the association is somehow responsible. I'm going to be addressing the first part of this analysis, and my colleagues on the panel will be addressing the second part. So the amenities that we'll be talking about today include your clubhouses, pools, fitness rooms, tennis courts, pickleball courts, bocce courts, basketball courts, playgrounds, and tot lots. Each presents its own unique set of factors to consider as they relate to the transmission of the virus. For instance, inside versus outside, small gatherings versus large gatherings, close interaction versus distanced interaction, several high-touch surfaces versus few such surfaces. Those are just some of the considerations. Each type of amenity has been addressed by the several executive orders from Governor Murphy, and some have also been addressed by other governmental guidelines, such as from the federal CDC and the New Jersey Department of Health. The first executive order addressing the coronavirus was number 103, in which that's the one in which a state of emergency was declared, and that came down on March 9th of 2020. On March 21st, Executive Order 107 was issued, And that was essentially the lockdown order here in the state of New Jersey. And I think we can all admit that our lives changed that day. So it literally is almost exactly a year that we have been in lockdown. But as you all know, slowly but surely, the governor has lifted that lockdown order, but not without limitations and restrictions. The most recent executive order was issued just last week, executive order number 230, and it takes effect tomorrow, the 19th of March. And those executive orders took into account the nature of these social gatherings in our state. And so they addressed each of our association's amenities a little bit differently with regard to the limitations and restrictions placed on them. So why don't we talk about the individual amenities and see how those executive orders address them and how we can address them in a way that's going to limit the transmission of the virus amongst our members when they use them. Okay, next slide, please. All right, so let's start out with pools. It's going to be the toughest one. I think you all know that. Executive Order 153, and that was back, I believe it was in July of 2020, was the first executive order that allowed the opening of pools, but it required the opening of pools in compliance with pronouncements by the New Jersey Department of Health. And that was entitled New Jersey COVID-19 Outdoor Pool Standards. That came out in July of 2020. By the way, everybody, if you want to see all of these executive orders and these other pronouncements that we'll be talking about today, for instance, from the DOH, you can go right to our webpage, hillwallack.com. And if you go to our COVID-19 landing page, you will have links to all of those particular items that I'll be talking about today. So as many of you know, the Department of Health's outdoor pool standards are pretty onerous. It's a lot to do, a lot to manage, and it's probably going to involve a lot of cost. As you all probably know, a vast majority of associations last year did not open their pools, and that was probably one of the main reasons. And what we have done is I've actually, along with my partner Lauren, have written a letter to the DOH and asked them to back off a little bit on those pool standards and to make it a little more flexible and easier to comply with. We haven't heard back yet, but we're hoping for an answer. So those standards included the things that you've heard about in terms of the gate checkers and the ambassadors and the cleaning of surfaces and the cleaning of bathrooms and the social distancing and all of those different things that apply specifically to pools. One of the things that those particular standards imposed was a 50% max capacity of your pool, which you could only have 50% of that max capacity in the pool area at any given time. So that means you're going to have somebody managing the gate. I will note that Executive Order 230, the most recent one, increased the permitted number of people in outdoor gatherings from 25 to 50. So even though the pool standards maxed it out at 50%, it can't be more than 50 people at any given time. Okay, next slide, please. All right, clubhouses. Executive Order 152 was the first executive order that began to lift the restrictions and the lockdown on indoor gatherings. And of course, that would cover your clubhouses. For those of you who have restaurant facilities in your clubhouses, Executive Order 183 actually covers what the lifting of those restrictions on those restaurant facilities. And Executive Order 230 again increases the permitted number of people in indoor gatherings from 10 to 25, but it also affected the max capacity of the room if you have a restaurant in your clubhouse. So again, you can have 50% max capacity, but it can't be more than 25 people. All right, moving on to the next one. Gyms, for those of you who have either separate health facilities or gyms, or if they are a room that is within your clubhouse, Executive Order 181 is the one you're going to want to look at. and that deals with the reopening of health clubs and gyms. You might also look at Administrative Order 21, which also deals with the reopening of health facilities and gyms. Unfortunately, some of the administrative orders that we have seen are difficult to interpret and lend themselves to various interpretations. I've heard it said that Administrative Order 21 doesn't apply to condominiums and cooperatives. I think the argument can be made that it does. And we certainly want to make sure that all of you are managing those gym facilities in a way that promotes the health of the folks that are in there. And to be more specific, you're going to go to the Department of Health's New Jersey Guidance for Health Clubs, Gyms, and Fitness Centers, which was distributed on August 27th of 2020. Interestingly, Executive Order 230, the most recent one, increased the permitted number of people in the gym from 35% of the capacity of the room to 50% of the capacity of the room. But remember, going back a slide or two, you don't have to do that. You can only have a max number of 25 people at an indoor gathering. So you can have up to 50% of the room, but it can't be more than 25 people. Okay, moving on to the next one. I've heard it said from a lot of our clients, board members and managers, that tennis courts and pickleball courts and basketball courts, golf courses, if you have them, those are all outdoors. They don't really lend themselves to close contact amongst the folks that are participating. If you, for instance, got a tennis court, you've got usually the most you're going to have is 4, right? Same thing with pickleball courts, and there's some truth to that. Remember that one of the considerations of how transmissible the disease is amongst people is how close they are. And these types of amenities don't necessarily lend themselves to close quarters. However, Executive Order 147 specifically dealt with tennis courts. There is no separate Department of Health guideline that was distributed, but those executive orders say that associations must still, or I should say the landowner must still perform certain minimum standards of healthcare protection for the folks that are using those. And again, I'll remind you that Executive Order 230 maxes out the number of people at any of those outdoor gatherings at 50 people. Next. Okay, playgrounds and tot lots. Many of you have playgrounds or tot lots as an amenity at your association. We know that not only do playgrounds and tot lots gather a lot of children on them, but also parents that are there monitoring their children. So you still have the ability to transmit the disease. Fortunately, I think the scientific evidence is that children don't, if they get it, and they get it in lesser numbers, but if they get it, they tend not to get as sick. But they still, according to the science, have the ability to transmit the disease. And if you have a bunch of kids climbing up and down on the playground equipment, you know you're going to have a lot of high touch surfaces. Executive Order 157 dealt with playgrounds and the lifting of the lockdown on playgrounds. And again, you can't have any more than 50 people in those areas. One of the questions that we've been getting a lot is, can we just put up a sign saying enter at your own risk and then let it be? And it's going to be, at least my recommendation, I think you'll hear it from some of my colleagues, that that's not good enough. An association does have an obligation to at least take reasonable efforts to monitor the use of their amenities. You cannot rely on the fact that your folks, your residents, are going to follow the rules, because you know there's going to be some that won't. So there has to be some minimum amount of monitoring. What that looks like, there's no standards for it. It has to be reasonable, and I suppose reasonable is in the eye of the beholder. But we can talk about more about that when we get to the question and answer round. I'm done with my section, so we'll move on to the next.
Thank you, George. Terry Kessler is going to talk to us now about tort immunity.
So good afternoon. George just told you about what you can do to open up your amenities as safely as possible and to prevent the spread of the virus. But even if you decide to open up your amenities, you still need to consider the fact that there is probably no insurance coverage if someone were to contract to file a claim because they contracted the COVID-19 on your amenities or while engaging in some activity at your community. I'm going to talk to you about tort immunity, which may assist an association to prevent, to avoid liability if such a claim is brought. Okay, first slide. Okay. So NJ, the New Jersey statute 2A 62A-13 is the tort immunity statute. And this statute provides that where the bylaws, and the language is important, where the bylaws of a qualified common interest community specifically so provide, the association shall not be liable for any civil action brought by or on behalf of a unit owner to respond to damages as a result of bodily injury to the unit owner occurring on the premises of the qualified common interest community. And nothing in the act grants immunity for bodily injury where there's an allegation of willful, wanton, or grossly negligent conduct, or a commission or omission. Next slide, please. So this act is very specific in that it requires the approval of 2/3 of all the owners other than the developer. And regardless of what your governing documents say, you have to amend the governing documents. You cannot use Radburn. You would have to take a vote. 2/3 of your members would have to approve this. And when they say other than the developer, that means if 75% of the units have to be owned by the unit owners and not the developer. And the governor specifically put that in there when this language or statute was passed so developers couldn't avoid liability for personal injury on the property while we're still in control of the association. Next slide, please. So because it's difficult to get passed, some of the things that you could use to get it passed is to point out to the owners that if the association's actions are, it would only apply if the association's actions are negligent. It will not apply if the association is grossly negligent or the behavior is intentional. And so if you can explain that to your owners so that they understand that they still will not, they still can bring an action against the association, it's just for negligence. Also, if you can keep the number of claims down because you've passed this, so if a unit owner, if the unit owner brings a claim, you can get it dismissed as long as it was negligent. You'll keep the number of claims down, and the insurance companies look to see the number of claims that an association has. That's how they base, the different companies that are willing to write insurance for the association and to keep the price competitive. Many managers have told me that the insurance company specifically asks the association if they have this amendment and suggests that the association get the amendment passed, because it may not reduce it, but as you know, insurance can be a very high portion of your budget, particularly for a small association. So it really makes sense to try to get it amended so that you can get the benefits of having that amendment. Next slide, please. Now, when I read you the language, you will note that it only applies to the unit owners and the spouse. It specifically states that. And so that means that it doesn't apply to children, tenants, contractors, guests. So if any one of those can still bring an action. Also, it only applies to the association. It doesn't apply to the board members or the board or management. So a lot of associations still have a duty to defend the board members and management. You may have a contractual duty to defend the manager as well. So if a claim is brought and names any of those other parties, you're still going to be required to provide a defense for those parties as well. In addition, as we discussed, since there's no coverage for COVID-19, the association is still going to incur defense costs. If someone files a lawsuit, you're going to have to take some action to get that lawsuit dismissed. So you're going to have to file an answer. You're going to have an attorney answer on your behalf. And then you're going to, what typically would happen is the attorney would file a motion after the answer's filed and request that summary judgment be entered on behalf of the association because the action was negligent. You have this amendment and the association should not be responsible. They are immune. Next slide, please. And what I want to point out is that anytime you have to do that, if you have to file the answer and there's no insurance, that means that the association incurs all those expenses, and that can be very expensive, even just to get to the point where we get the action dismissed. Now, it doesn't apply, as I stated, it doesn't apply to gross negligence or intentional acts. So more and more attorneys for the plaintiff are understanding that, so they just allege that the action that occurred was more than mere negligence. It was gross negligent or intentional or willful or wanton. And if they make that allegation, then it becomes very difficult to get it dismissed right away, because then you have to prove that the actions were just negligent. Now, we had a case in the office where the attorney alleged that it was gross negligence, and it literally took 3 years, and I can't begin to tell you how much in legal fees until the case got dismissed. The judge did ultimately dismiss it, but it took a long time before he actually agreed that no, the association was just negligence. They have this provision, and so I'm going to dismiss this case. So what you need to know is that it's not foolproof. So just because you have this amendment, that doesn't mean that you have the amendment and so you're not going to be liable. In fact, if you don't want to be negligent, then you have to follow all of the state and local guidelines that we discussed, and we're going to discuss more, all the protocols, because if you don't follow them, then you are negligent, because you didn't follow the guidelines and you knew what you needed to do, but you didn't do them. Next slide. Is there another one? The one more thing I wanted to point out is that there's an issue about what is bodily injury. And if you notice in the language, again, I said that was important. It refers to only bodily injury, and bodily injury is, they define it as bodily injury or physical injury or death. But the insurance companies, when they exclude COVID-19 from coverage, they exclude it because they say it's for infection or disease. So they define COVID-19 as infection or disease. So when this statute was originally passed, people will argue that it was meant only to include, slip and falls, physical injury to the body, and not what was meant by an infection or disease. So there is an argument that it may not apply, but there have been no cases, so we don't know how that would go, but that is something to consider. And the next thing is our polling question.
Thank you, Terry. So we're now going to put our second polling question up and ask you to take a few seconds to respond to this. Are you planning on reopening? Thank you. And the results should pop up. 58% of you would like to plan or plan to open your pool. 28% the clubhouse, 33% who responded said the gym, 16% who responded said the tot lot, 27% who responded indicated only outdoor activities, 3% said none of the above, and 41% of those who responded said they don't know yet, which I think is a good answer, because I'm not sure anybody knows what they're going to do today. Okay, our next speaker is Ron Pearl, who is going to be discussing COVID-19 waivers and how useful they are.
Well, good afternoon, everyone. I'm pleased to be with you this afternoon to talk about waivers. The waivers are the flip side. Let's have the next slide, please. Waivers are kind of the second part of the tort immunity and waiver defenses. So, this is all about handling risk, evaluating risk, and deciding how much risk an association can tolerate. The issue is that there being no insurance, we have to evaluate the association's exposure to lawsuits, to, as Terry said, the cost of defense, which is sometimes worse than the ultimate judgment. So we have to figure out how to protect the association from being sued, from defending suits when we don't have any insurance. So Terry talked about tort immunity, which isn't perfect. It's not the silver bullet. And one of the reasons, we're talking about it is because there's been a lot of buzz in the industry lately about, oh, let's hurry up and amend our documents to include tort immunity. There are a lot of holes in the tort immunity provisions, as Terry said. First of all, the enormous task of getting it passed. And then Terry described the holes there. Waivers aren't perfect either, but that's what I want to talk about today. My personal opinion is that you're much better off relying on waivers than the tort immunity provision. And I'll tell you why. First of all, let's talk about what a waiver really is. It's somebody's knowing and intentional relinquishment of a right. It means that somebody, in plain English, is giving up the right to make a claim that they may otherwise have. And so in the case of COVID-19, we're saying to people, listen, if you want to use the facilities, we're willing to open them up, but we have this enormous risk because we're not insured for claims relating to this illness. And therefore, we would like you to tell us that you agree that you are not going to make any claims against us, and you're not going to hold us responsible. As long as we follow the rules, we can't, it's not perfect. And we can't assure or guarantee that a person will not become infected. So that's why the waivers, you may have heard this before, waivers are sometimes frowned upon by the courts. Why? Because they don't want people that are providing a service to be able to be negligent or careless or reckless. And as a result, people get hurt. By having the people waive all their rights, give up their rights to make a claim if that person causes their injury. So while there is some disfavor in the courts for waivers, in my opinion, a carefully drafted waiver can protect an association in this situation. So in doing research for this, I actually found that there are cases involving facilities like health clubs, where as long as the proprietor of the health club isn't trying to escape from some duty that they've neglected, these waivers can be upheld. Let's go to the next slide. So these are the questions that the courts will ask in evaluating whether to uphold your waiver or not. Was it knowing, voluntary, and intelligent? Was there any fraud involved in obtaining it? Is there a matter of public interest? In other words, is there a public policy reason why these COVID waivers shouldn't be allowed? And I think it's quite the opposite. There's a strong public policy reason that I'll talk about a little later why they should be allowed and should be supported. Is there some duty to perform that the person getting the waiver is somehow able to avoid? And is there an inherent risk in the activity that makes some assumption of the risk reasonable? Can we have the next slide? So the waivers that we use, and I know other attorneys use, are really much more than waivers. Although they're titled waivers and we refer to them as waivers in conversation, they accomplish more than just waiver of a claim. First of all, there's an important concept called assumption of risk in the legal world. COVID is a well-known risk. I don't know anybody who hasn't heard of COVID. I don't know anybody who hasn't seen news article after news article or television program about the pandemic that we're in. There's general knowledge about the risks of COVID, and the risks essentially are everywhere. So we include in our document, the one we call a waiver, we include a specific assumption of risk. I acknowledge the dangers of waiver, and I agree when I use your pool, gym, clubhouse, etc., that I'm assuming a risk that I could contract COVID in that situation. Also, our waiver forms contain an agreement not to sue. Now, agreements or covenants, they call them, covenants not to sue, are accepted in the law, and they are recognized in many situations. And in this particular case, we're asking people, well, we don't want to have a million lawsuits just because we open the clubhouse. And how would you determine that you contracted COVID in the clubhouse rather than the local supermarket that afternoon? So we're asking for an agreement not to sue. And of equal importance, we're creating a contractual obligation of the residents not to come into the clubhouse when they're either exposed to COVID or actually ill. We have the next slide. And certainly we have a good reason to do that. And if a person knowingly agrees not to come into the clubhouse when they're sick, and they wake up with a fever and can't taste anything in the morning and come to the clubhouse anyway, they're in violation of a contract, and it's a reasonable requirement to ask of them. So what are the benefits of having this document, this waiver document? It clearly identifies the risk. It makes it clear that the resident is agreeing to use the facility subject to that risk, and is exposing themselves to the general risk of COVID. And it contains the agreement not to sue. But I'll tell you that it's not absolute. Nothing is absolute. And just as the tort immunity is not a silver bullet, this is not a silver bullet. Although, you know, I've said it again, I favor these waivers. I'd rather be protected by a waiver than the tort immunity, because even here, if you're grossly negligent, if some associations are talking about just opening up, just reactivating everybody's fob so they can get into the clubhouse and opening up, that would be grossly negligent, and you wouldn't be entitled to either immunity or the protection of a waiver in that situation. It's reckless. One theme you'll hear throughout this presentation is follow the published standards. That's the protection. All of the protections that you have are based on associations following the published standards. And I know there's going to be a question about how some of the standards, like, for example, gyms or pools, may apply to larger commercial facilities. Nonetheless, they are the only published standards we have. And if you don't follow them, you're looking for trouble. We have the next slide. So let's talk about this public policy issue that I want to address. Obviously, you know, in the face of the pandemic and the need to get people back to as normal a situation as we possibly can, people need to have access to the recreational facilities for which they pay. I think everybody would agree that getting people back into clubhouses and recreational facilities in the association world is a necessity and should be done as soonly as safely possible. And I stress safely possible. So The courts in this kind of situation, and I've researched the case law, they balance the risk, the benefit. Are you protecting somebody that legitimately should be protected, or are you protecting somebody who should not be protected in this situation because they can cause people's illness, for example, or injury to people, and they just want to get away from that kind of liability. And I think in this situation, the balance is struck between allowing people who are aware of the risks, who are painfully aware of all the requirements, masking, distancing, and all the rest, to allow them to safely use facilities that should be available to them by limiting the risk, not eliminating it, limiting it, and transferring the risk to the users. I think that, and this is just my personal opinion, that the courts have every reason to say that that's consistent with public policy and doesn't violate it. So I'll see you again when we deal with the questions and answers, but that ends the subject of waivers.
Thank you, Ron. Our next speaker is Jessica Baker, who will review some contract provisions.
Thanks, Caroline. Let's go to the next slide. Although we are hopeful that life will be returning to normal soon, unfortunately, I have to discuss the reality that we are not out of the woods and that a surge or a lockdown could be a possibility in the future. We are still in this pandemic, and this is going to impact contract terms we see proposed by contractors and the provisions that we want to see in a contract to protect the interests of our associations. So my first point is that every contract an association is considering now should be reviewed in light of the pandemic. We might all have pool contracts on our mind right now, but every contract the association enters into could be affected by the governmental restrictions in place and the possibility of a lockdown. Next slide, please. There are contract provisions that I always look to as critical to protecting the interests of associations. This is true pre-pandemic and during the pandemic. The three provisions are termination, insurance requirements of contractors, and indemnification of the association. Those provisions remain important now, given the uncertainty of the world. And I'm going to run through these provisions very briefly. The first is termination provisions. A termination provision allows one or both parties to terminate the contract. The provision can allow for termination with cause or without cause, and may provide for a certain number of days notice for termination. In the uncertainty of the world, this is incredibly important because if the association would like to terminate a contract, this is the first provision we're going to look to. Next up is indemnification clause. This topic on its own could easily be a 3-hour webinar, but very broadly, this type of provision will require one party to reimburse the other for certain costs and expenses resulting from a claim or claims brought by a third party. If there are lawsuits stemming from injuries related to the pandemic, this clause could come into play. Indemnification clauses may also require a party to defend the other, meaning if there is a lawsuit, one party may have to pay the costs and expenses of the other, or even just provide the defense to the other party. Number 3 on my list is insurance requirements. This type of provision would require contractors to maintain certain types of insurance in case of an accident. Again, we don't know what types of lawsuits are going to be filed because of this pandemic, so we want to ensure that all contractors have insurance in case of an accident or incident. So again, those are just the 3 provisions I look to, but there are other provisions which have become very relevant during this pandemic. One such provision is a force majeure clause. This is a provision that you've probably seen in contracts before, but maybe never gave much thought to. A force majeure clause is a provision that is going to relieve the parties from their contractual obligation when certain circumstances beyond their control arise. In such a clause, you'll see a list of events that might excuse performance of a contract. Examples would be acts of God, weather, earth movement, And now you're probably going to start seeing pandemic and governmental restrictions as part of that list. So although this provision may be very helpful to parties during a pandemic, just keep in mind that this type of clause isn't just going to excuse a party from a contract if it's suddenly inconvenient or they change their mind. So because of the pandemic, clauses are being added to contracts to specifically address COVID restrictions. For example, you might see language requiring that contractors are abiding by restrictions and requirements relating to COVID. Additionally, in negotiating contracts now, you may want to consider language to allow the association to alter a contract depending on certain circumstances. Again, there's been a lot of uncertainty in what the future will bring, so sometimes we want to try to predict and put certain language into our contracts. I'm going to give a brief example. Again, we all have pool contracts on our mind. Some associations may be deciding to open their pools now and are entering into contracts for maintenance and lifeguard services. But they may want to start thinking about or negotiating now to have the option to switch to a maintenance-only contract during the season if certain events occur. Again, we don't know what the future is going to bring. This is an example of a way that our associations can try to prepare for the uncertainties in the future. Just as we are trying to protect the interests of our associations, contractors are trying to protect their own businesses and their own interests. And I bring this up because early in the pandemic, we saw a lot of unavailability of materials and suddenly workers too. So we should also be on the lookout for contractors requiring provisions about price escalation due to COVID. For example, contractors may be trying to pass along these increased additional costs to the association by including provisions that allow for price increases due to the availability of materials and workers. So a discussion about contracts, again, could be its own seminar, but these are just some key provisions and terms and contracts you should be aware of during the stage of the pandemic.
Thank you, Jessica. And our last speaker is Ken Sauter, who's going to talk about vaccines.
Thank you very much. Thanks for everybody for sticking with us. We appreciate your interest in the topic. We know it's a very difficult one. So the final question I have is, can you require vaccines or proof of vaccination? And secondly, should you? They're both pretty big questions. I could just tell you next slide, please. We're pretty much in uncharted waters still. There's very little guidance on these topics, and what guidance we have is somewhat limited as to whether or not you can require proof and if you can impose that proof of vaccination as a condition of the use of community amenities. Next slide, please. So what we try to look to is analogous laws, because there really isn't too much out there to give us specific, strict guidance. And what we find is that there are federal laws that really talk about the employment arena, the workplace, and they're telling us that under federal laws, at least, that it is not inappropriate, that you're not restricted as an employer for asking an employee to provide proof of vaccination as a condition of returning to the workplace. There are exceptions to that. Employers have to consider disability accommodations and legitimate religious beliefs to avoid discrimination claims. New Jersey has similar laws with respect to discrimination. So in New Jersey, as an employer, you'd have to pretty much take the same position, provide and recognize the same kinds of exceptions. So next slide. So by analogy, can a community association with respect to the use of its amenities require proof of vaccination? And I think the answer is likely yes. I think you can require it. And that's almost the simpler question. Again, you have to consider the accommodations requested by your individuals. You have to consider the exceptions to it for legitimate religious beliefs. But likely we believe that an association could require vaccination as a condition of the use of amenities or proof of vaccination. Next slide. But the question really is, should an association do it? What is it undertaking if it tries to impose that kind of a condition? Um, you have to take a look back at your governing documents, particularly your bylaws, and see what kinds of powers your association has to require this. You'll probably find something in there that's a generic, broad power regarding things like health, safety, and welfare. There are statutory provisions that likely give the association the power to delve into those kinds of issues and try to provide those kinds of protections. So you start again with the position that you likely can enforce that kind of a requirement. Next slide. But the bigger question then becomes, how do you enforce it? That's the tough one. We always talk about, what an association can do, but in the practical world, it's what is the association really able to do and to implement and to enforce. So questions will come up, and I'm sure there are going to be many more than I can even think of regarding things like proof of vaccination. What kind of physical proof are we going to accept? Who's going to monitor and maintain the records of that? Right now, there are no vaccination passports. There may be someday. We're not there yet. Can you require somebody to provide you a medical statement if they're requesting an exception? We've all been facing the emotional support animal claims where somebody has a pet, has a dog, says they have a medical necessity for it, and they provide us with some kind of a certification. We may be able to do that, but we really can't delve much further than that once we get the answer from a credible source, I'll say, that a person has a medical exception to obtaining the vaccination. So you do run into HIPAA-related issues at some point. Could you request a healthcare provider statement similar to what we do with emotional support animals? Probably. And then the question is, how do you test somebody's legitimate religious beliefs? That's a tough one because we don't all carry the Bible around or the Quran around with us. Next slide. More practical issues for an association to consider. If you're going to invoke the health, safety, and welfare powers of a board, are you then assuming some higher degree of liability than you otherwise would have? We are, uniformly cautioning our board members and our associations about getting overly involved in areas that really aren't within the expertise of the association. We're not healthcare providers. We're not the ones who are trained in these kinds of issues. So you really have to be careful about what kind of requirements we're going to impose and undertake. There's a question of simple fairness. If somebody can't get the vaccine, and it's not a legal question, it's just a practical question, how do you deny that person access to the community amenity? They didn't do anything per se wrong. Same thing with respect to children. If children are not eligible for the vaccine and they aren't yet, how do you deny attendance at the pool because they haven't been vaccinated, and yet you're imposing those requirements across the board? It's a question more than an answer. Next slide. I think the most practical advice I can give is, what are others doing? You've heard us repeatedly saying there is a standard out there as to what we should be doing as community associations. And it's that standard that will generally determine whether or not negligence exists and whether or not there's liability. So take a look at what other similar facilities are doing. We talked about there being no standards specifically for community associations on their gyms, but there are public fitness facilities, your local Y. What are they doing? If you look at them, you're probably not going to find, at least yet, that any of them are requiring vaccination. At least I haven't seen that. So bottom line for my part of the presentation is there isn't any simple answer to it. It's pretty much been the conclusion for all of our COVID-19 discussions. But you just have to carefully deliberate. Are you going to require this? And if you are, what are the implications of trying to enforce a requirement that somebody provide proof of vaccination before they actually are admitted to your amenities? Next slide. And thank you.
Thanks, Ken. So we have received quite a few questions during the presentations that I've tried to group into the topics that were presented. So if you'll indulge me, I'm going to direct them to the various presenters. And however, I encourage all of my colleagues to please answer. So let's go to contracts. Jessica, there was a question as far as how can a contract be amended to include some of the provisions that you reviewed if the vendor does not agree to the amendment. So the association wants to amend the contract predated COVID. The vendor will not agree. Perhaps what do you think?
That's a tough one. And that's why, I brought up the first clause being termination provision is something that, pre-pandemic and now we always want to make sure we have an out if we can, if the contractor will agree to it, to terminate. I think it's going to come down to what the association is trying to amend in the contract, and what the contractor is not agreeing to. I think that's really going to be important here. Obviously, there's restrictions in place now that the contractor has to follow. So if you're trying to put terms like that into the contract, those are provisions, and restrictions that they have to follow at this point. So it's really going to depend, I think, on what you're trying to amend in the contract.
Okay, thanks. Terry,
Aye.
a couple of questions on tort immunity. One question was, how do you count a unit if the owner is deceased as far as the 2/3 is the requirement?
The law says 2/3 of all owners, if they're deceased. I mean, I've never heard of removing them from the count. I mean, it's 2/3 of I don't know what my panelists say, but I say it's 2/3. That's what the law says, 2/3. That's what you have to do. You have to get it approved by 2/3 of all the units. So if there's one, that's a no vote. That counts as a no vote.
Well, but I'll add that there's also an estate. When somebody dies, there's still an owner. The owner is the person's estate, and there's usually an executor. And but Terry's right. If that executor, despite your attempts to get that person to vote, just chooses not to, it's just like any other owner that doesn't want to vote.
Okay.
By the way, Caroline, I
Yes.
saw a question that someone asked, well, can't we do this by the 10% rule of amending bylaws? And the answer
That was the
is no.
next one.
Okay. Go ahead, Terry.
No, the answer to that is no. It's very specific. Like I said, you have to look at that statute and abide by the terms of that statute. And that statute provides 2/3 of all the members have to approve it. And that's after, like I said, 75% of the unit owners that are unit owners and not developer owners.
Does tort immunity apply to the transmission of COVID?
No, we don't know. That's what I was speaking about. So it applies to bodily injury. They explain bodily injury as injury or death, and so we don't know what that's gonna entail. But like a transmission, in order to have the tort immunity, you have to have damages. So if you're just transmitting it, I don't know, that there has to be damages. That's not the whole picture.
I just add here that the issue of bodily injury is a real serious question, and the definition of bodily injury is normally in an insurance policy. So if the contraction of an illness is not within the definition of bodily injury, then it's not going to be protected by tort immunity either. So that's one that we're going to have to get the insurance coverage lawyers and the insurance agents involved. But some people have already given the opinion that bodily injury doesn't include, bodily injury is injury. Tiger Woods has a bodily injury. But if you contract a disease, does that constitute a bodily injury? That's the question.
Okay. Subsequent question.
Caroline,
Yes.
there's a related issue, and tell me if you're going to reach it later, but board member immunity is different, because I just want to point out that there are provisions in many governing documents that they sometimes call it exculpatory provision that protect board members from decision-making made in good faith. So there may be protection for board members in your governing documents, quite apart from the immunity provision.
And I saw one other question that I wanted to point
Yeah.
out. I don't know if you're going to get to it about tort immunity, but tort immunity, I have seen it work. And, not with respect to COVID-19, but I just recently had an association. One of the owners tripped and fell in the parking lot, brought the lawsuit. The insurance company immediately, it filed an answer and then filed a motion for summary judgment. And the summary judgment was granted, association out. So it does work. So it's, whether it's going to work for a COVID-19 claim is the question.
Okay, can you limit tort immunity to just the recreational facilities?
Well, I'm not sure what that means, though. It's going to apply. Are you set as, I don't know.
The question is, can it be limited to the recreational facilities rather than the community in general? So can you be very specific as far as what tort immunity will apply to? Just the clubhouse, perhaps?
Could you limit a tort immunity provision just to specific
Yes.
facilities?
Yes.
I don't, George, you're muted, but you had that question before. I don't see why not, but I don't know why you would want to do that. You're
I
muted.
think people are trying to sell the tort immunity during the COVID-19
Oh, right.
pandemic.
So maybe you want to do
Trying to
it.
tie the two together.
Yeah.
Well, the related question is, can you limit it to COVID claims? You could try. I mean,
Yeah, you could try, but but like we said, we don't know if the COVID claims are going to be, covered. So that's the issue. I know.
It would be my opinion that you can limit that provision that you amend your documents with as limited as you want it to be. Whether you limit it to certain types of injuries, you limit it to certain portions of your development, you can limit it as much as you want. You just can't make it broader than what the statute allows.
Right. You can't make it broader and right. And so that would be, even if you're making it limited, and it's going to include COVID, but if bodily injury isn't included, then, if that's not bodily injury, then you can't make it into something that it's not.
Okay, another question is, do you require the approval of the eligible mortgage holders for tort immunity?
No, not in accordance with the statute.
Okay, let's change course a little bit and we'll go back to George with the amenities. A whole bunch of questions about the amenities. Do any of these executive orders apply to recreational fields, like a soccer field or a baseball field, to your knowledge?
Who was going to bet I didn't unmute myself this time? The answer is there are none of those particular types of amenities that are specifically addressed in the executive orders, but they're considered places where folks are going to gather outside. So you still want to have a reasonable attempt to enforce minimal health standards for your residents, whether they're out doing a pickup game of softball or something like that, it will still apply.
Okay. There were several questions about the status of the immunity bills in Trenton.
Yeah, I can speak to that. As the chair of the Legislative Action Committee, I'm keenly aware of our status and our efforts. We have been doing the best we can. We were fortunate to have a couple of sponsors in the Assembly to introduce an immunity bill specifically related to community associations. We are hopeful that we are going to soon have a Senate sponsor for a companion bill. And then as soon as that happens, we will likely be reaching out to all of you to ask for your support, to reach out to your Assembly and senators to encourage them to pass that immunity. Whether it's passed and whether it's favorably looked upon by the governor is yet to be seen, but we're fighting the good fight.
Okay. Several questions about various amenities. What are the requirements applicable to tennis courts versus bocce courts and stuff like that? Are most of those addressed in the various executive orders you mentioned before?
Well, I think, as I said earlier, the only amenities that have specific Department of Health guidelines issued are pools and gyms and fitness facilities. That doesn't mean that the executive orders don't address those other amenities, because they do, but they do not reference a specific set of guidelines that are published by a different governmental entity. So what that means is is they use the term minimal health safety standards. And what does that mean? It would generally mean the same things that we hear every day: wearing a face mask, social distancing, washing of hands. Those are basically the minimum set of standards that must be enforced to do what we can to ensure the transmission of disease doesn't occur more within our communities.
Okay. What are the consequences if the association does not follow the directives of the executive orders or the Department of Health? We had a few questions about that.
Yeah, I'm looking at Executive Order 230 right now, and there is a provision. It's usually the last 2 or 3 paragraphs in almost every one of these executive orders that says that there are in fact penalties for violations of these orders, and it references certain statutes that are in existence in New Jersey. But I can tell you that it would include at least 2 things. Number one, monetary penalties and shutdown of your facility.
Can I mention, Caroline?
ahead.
I'd like to mention, we haven't talked too much, and the question was about the general facilities, outdoor and indoor. This issue of opening clubhouses is interesting because, you know, we're talking about the limitations on indoor gatherings, you know, which now are 25 people, and people on this call will be involved with clubhouses that have multiple rooms and gyms within clubhouses, and you know, so various facilities. And George, you may want to weigh in on this, but I think that the larger clubhouses, all clubhouses, but especially the ones with multiple facilities and multiple rooms in them, require some pretty detailed planning, because you never want to violate the maximum in a given gathering. And it may be legitimate to have 2 separate gatherings of 25 people in a clubhouse, but you have to be concerned about where the locations of the bathroom are, the entrances and exits and foyers where people may gather, because while you may have 2 distinct 25 person gatherings, if they start to intermingle with one another, now you have a 50, and it violates the executive orders. And plus, if somebody contracts COVID as a result of that, then you have a real problem. So this requires planning, keeping people apart. We all know what the sense of the standards and executive orders have been. A frequent cleaning of the high touch surfaces, and as George said, the distance and masking. So it really takes a lot of planning with the board, management, and so on. You can't just fling the door open to the clubhouse and say we're back in business, at least not in New Jersey. Maybe in Texas, but not in New Jersey.
Yeah, Ron, I think you're right. For instance, if you have a clubhouse that has 4 different separated rooms with a max capacity in each room of 25, you could say that there's a maximum in the entire building of 100, right? But you can't rely on that, because, as you say, there are common entrances, and you may end up having 25 people from one room coming out while 25 people are going into the other room, and then you're talking about people being in the same area, and that's what these governmental orders are trying to prevent, is large gatherings of people in close proximity. So Ron's right. You've got to have advanced planning on how you're going to address the limits on the number of people that can be in your building at any one time.
Okay. Let's mix it up a little bit. There were a lot of questions with regard to tort immunity and waivers. Is it recommended that you do one or the other? The bylaws be amended to permit tort immunity or a waiver? Should they attempt to be done together? A lot of questions about that.
Well, let's start with the proposition that waivers are more immediate. I mean, you can, by action of the board, mandate waivers, and so I would start on them first. I don't want anybody to think that I'm saying don't do the tort immunity provision, but that takes a lot of time. It's a vote, circulating ballots and all of that stuff. And in the meantime, you're going to want to open your facilities. So, and you may not get the 2/3 vote. So all of those things being considered, let's start with waivers and get them done immediately. And by the way, I saw a question, and yes, the waivers cover board members, management, et cetera. So to some extent, it's another reason why they're an advantage. If they're effective, they're an advantage over the tort immunity, which has those limitations. So you protect the board in a waiver, you protect the management company, et cetera, by doing a waiver, and it's as almost instantaneous. So that's why I say start with a waiver. I'm not discouraging anybody from tort immunity, but we wanted to point out the limitations of both.
Right, and tort immunity will take, it will take a considerable effort to get it passed. I have had associations pass it, but not the majority of them that tried it. But it is, like I said, it is good to have it. If you can get it, it's great to have.
Yeah, and the reason we got questions about limiting it to COVID or limiting it to specific facilities is because you will get pushback from your residents. And some of you have already experienced that. So that's why people are talking about limiting it. It's not a foregone conclusion that if you offer it, it'll pass.
So since tort immunity, actually, let me take a step back. What about bylaws where the builder put the tort immunity language in the bylaws? What do we think about that?
Well, we think that if the developer put it in there and the developer has long since gone, that it is enforceable. There are arguments that can be made that we've heard it, that says that if it was in there, that it's not going to be enforceable unless it's approved after by 2/3. But I've seen it enforced otherwise, and that would have to be an argument that a court would have to decide. But the point was to not allow the developer to get off for personal injury on a slip and fall while he was still in control. And, if it's been passed, you bought it, you saw it in your documents, you had notice of it. And so I think it's enforceable.
Okay. Should waivers be signed every time somebody wants to use the pool or go into the clubhouse? Should they be specific to a particular amenity, or can it be a general waiver for all amenities that's signed once at some point?
Every manager on this webinar is cringing right now. It's a nightmare to do it every time, and it's not necessary. And by the way, should you allow guests must be made to sign the same waiver as residents, but most associations at this point, because of the limited access to facilities, want the members to have access and not be shut out because guests are there. But in either event, you can have one waiver that covers all facilities at all times, and none of the waivers that we've ever done have a termination date on it. They all are evergreen until somebody wants to get out of it. But it's a condition of using the facility. You have to sign it. I saw a question about what if a resident refuses to sign it? Well, then they don't use the facility. And you should strictly enforce that. So it's a one and done kind of thing. It covers all facilities.
Okay.
What about minors, Ron?
What about
minors? Sorry, Caroline.
That's okay.
What about minors?
Children. Do you think
minors. Well, the law is that even if a guardian or parent signs on behalf of a minor, if that child is injured, that they have, once they become of age, they can make their claim. So, sometimes in auto accidents, you've heard of friendly, or maybe you haven't, but if you settle an auto accident case in which a minor is injured, that has to go through a whole court process and approval by the judge in a hearing to determine the adequacy. So no, a parent can't release on behalf of a child. They have a right when they reach the age of majority to pursue a claim, and the statute of limitations won't help you because that's told while the child is still a minor. And by the way, I saw, on a related issue, I saw issues relating to the good repair of the facilities. You have quite apart from COVID, you have a general obligation to maintain the facilities in good repair. And so that's consistent. And if somebody signs a waiver and you have been grossly negligent in failing to maintain, let's say you don't take care of your diving board, since we're talking about pools, you haven't inspected or maintained it in 10 years, and somebody gets injured because it malfunctions, you're in trouble. So you got to always keep up with inspection and maintenance of all of your facilities.
Okay. Should you include an affirmative statement in a waiver that the association will follow all COVID requirements?
We put it in our waivers, we put it a little bit differently. We in the acknowledgement or assumption of risk, we say, we acknowledge that despite all efforts of the association, you may contract it anyway. That's the way we put it. We don't put in an affirmative obligation, a contractual obligation to do, follow all the guidelines, but that is understood. And if you don't follow all the guidelines, I will tell you that will invite a claim for gross negligence, because the guidelines are the minimum standards. And with regard, I know many of you feel that the pool regulations in particular are onerous, especially for smaller associations, and that may be. So if you're not prepared to follow them, you shouldn't open your pool. If you're going to open your pool, you have to follow them. Now, George and Lauren Lightman and CAI are working on getting those relaxed by negotiation with the Department of Health, but that's not here yet. We do understand that there will be some modifications this year around April, and we'll see what they are. But whatever they are, they need to be followed.
Okay, let's switch to vaccines for a moment. Ken, a couple of questions about asking if you could, or anybody could discuss a little further the HIPAA requirements. If we are asking for proof of vaccination, are we violating any HIPAA requirements?
You're allowed to ask for proof of violation. It's a proof of vaccination. You go beyond that, you run the risk of a HIPAA issue. You couldn't say, well, why are you refusing to get it? What's your medical issue? You can't ask the specifics of somebody was claiming an exception and presented you with some credible evidence as to why they couldn't get it medically. You can't go beyond that.
Do we feel it would be discriminatory to allow only vaccinated individuals to utilize the facilities?
Well, discriminatory and discrimination is an overused term because it really refers to protected classes. So there is no protected class at risk here except somebody who's claiming a medical disability or a religious exception. So no, it's not discriminatory.
Can we ask for proof of vaccination from a vendor for its employees who will be on the property?
I think as a condition of your contract, you could require that the vendor have individuals who are vaccinated. The question becomes, are you now so limiting the number of vendors available to you that it's impractical? So I guess it's one of those legally yes and practically maybe.
Can we ask everyone who uses the facility to show proof, if that's the rule, that they've been vaccinated? Should it just be limited to residents or non-residents?
I think you start with, are you going to open up your pool to guests? And most so far are not doing that because of capacity limits. But I would think if you're going to open up the pool and require proof of vaccination, it should apply to everybody that's using that amenity. I don't know why you would handle it otherwise.
But the fact that children can't get it, what about that?
Well, that was the issue I discussed before. If you're going to implement it, be prepared to deal with the issue of many people who are just physically not qualified yet to get it. Where are you going to draw that line? That's the practical question everybody's going to face.
Is it sufficient to just ask if a person has been vaccinated and not require any proof?
This is one of enforcement. I think if you're going to have this as a condition or requirement, you have to have something more than the honor system. It's not really working well for the vaccination program itself. So I think you have the right and probably should ask for a little bit more than somebody raising their hand and saying, yeah, sure, I got it.
Yeah, just the other day, I saw an example of how one association is handling it. They're making the person produce their CDC card, which everybody gets when they're vaccinated. And then they actually have fobs for entry to the clubhouse and other facility, pool and so on. And they put some kind of designation, whether it's a star or some other kind of symbol on that person's identity badge that they control. And that's how they know. So the person doesn't have to bring a CDC card every time.
We received several questions, and I'm opening this up to the floor as to whether or not we have knowledge of any lawsuits being filed against associations alleging that someone was exposed to COVID and or against a board for deciding not to open the facilities.
I'll take the second question first and say that I actually am personally aware of a lawsuit that was filed by a member of an association against the association and its board for not opening the pool. The allegation was that the person wanted a refund of the amount that was allocated to him in the budget for his pool assessments, as well as he wanted a reimbursement of the fee that he paid to the private swim club down the street. That's the one instance that I'm aware of, but you should all know that was ultimately withdrawn by this person. But we feel strongly that a board who chose not to open because of all of the different considerations that we're talking about today is justified in doing so, just like a board who chooses to open, so long as they know what they have to do to open safely, they also are justified. So, and we also believe, by the way, that if someone sues the association and the board for not opening, we believe that there is going to be D&O coverage, at least for the defense of that particular claim.
Ken, I'm going to throw this one to you. Are there any specific guidelines for lake associations and utilization of beaches?
It's really the same Department of Health regulations with respect to pools. Your capacity numbers are going to be a little bit higher just because of the area, and the measurements are different, but it's pretty much the same kinds of standards.
Okay, and Ken, you had a specific question, which is, one of our attendees had heard from another attorney, I guess, at another presentation, that it may be better to amend the bylaws to include the tort immunity language.
I just answered that one privately. That was my typing. And the answer is, I've never heard of such a thing. If you get the 2/3 approval of tort immunity under your bylaws, you're done. Why would you get any better protection?
If I could answer that, because I get that question a lot. So the way the statute is written, again, remember I told you that you have to look at the statute. The language is really important. It refers to bylaws, but the point is that the documents in general have to be amended by 2/3. It doesn't matter what portion of them you're amending, Master Deed bylaws. You need a 2/3 approval of all the members to pass it. And just because the statute says bylaws, you know, it has to be amended in accordance with the statute.
Okay, and I'm going to ask my fellow panelists to kind of scroll through the questions to see what I've missed, because there's quite a few questions, and I tried to do that. George, with the occupancy limits right now, if it says 50% or 25 people or whatever it's going to say at a certain time, do you look at the higher number or the lower number as far as the limitation?
Yeah, you have to look at the maximum number of people. It's either 50 for outside or 25 for inside. Regardless of what the 50% capacity is, it can't be more than that particular number. By the way, Caroline, I wanted to answer that first question second about whether or not there were any lawsuits. We're not aware of any lawsuits right now in which someone has sued an association for having contracted COVID, but please understand that there's a 2-year statute of limitations on those types of claims. It's only been a year. There's still time for those folks to find an attorney to file that claim. And it may very well be that because 84% of the amenities were closed last year, that there was very little, if any, chance for somebody to get sick by using an amenity.
I saw questions about municipalities opening up their amenities, and are they less liable somehow than associations?
Yeah, they actually are. The New Jersey Tort Claims Act provides the kind of protection or even greater protection than we're seeking for associations, but that's been around for years. The New Jersey Tort Claims Act protects public entities from certain kinds of liability claims. And so they have this protection. And while I'm answering that question, you know, the other thing that we hear from our residents is, well, the gym down the street's open, so why isn't ours? And so businesses have a different model than we do. You know, we're community associations, they're businesses. They are inclined to take greater risk because if they don't, they'll go bankrupt and close down. And that's another thing I've mentioned, bankruptcy. If they get a claim that's a real live claim that truly they were grossly negligent, failed to clean, somebody got sick, and they're headed for disaster, they have the bankruptcy laws to protect them. Less so for associations. But so when you're compared as an association to either a private business or a government, they are pretty much a different story, different set of risks. And I start out by saying this is all about assessing and balancing risk and seeing what you're willing to accept. They have different risks and they have different balancing act that they're employing.
Can an association require that masks be worn on common property? Anybody?
I think they can, but it's difficult to enforce. I mean, I think that they have to, you know, they can't just allow people to run around without them. But if they see it, they need to stop it, do what they can. That's what the law is. But, you know, it is a difficult thing to enforce, but they need to try it. And if you get a particular complaint, you know, from somebody, I think that, you know, you should be posting the signs and following all the general restrictions.
And again, if you ignore it, you're facing gross negligence allegations, which means tort immunity and waivers are out the door.
Is it a good idea to conduct an anonymous survey asking residents to confirm whether or not they have been vaccinated?
Well, I have associations that are doing that, and there's nothing wrong with it. I have advised them to just make it a yes or no answer and not ask, you know, I heard a question, well, can we ask which, was it Moderna or Pfizer, and when did they get it and where did they get it? The more information like that you collect, the closer you get to having to protect it for privacy reasons. So associations aren't amongst those covered by HIPAA strictly, but if you have private information like that, that's not the end of it. I mean, you have common law privacy considerations. So the idea of getting a sense of how many, what percentage of your residents are vaccinated is just a good idea if you're contemplating opening facilities and you want to know, you know, in a 55 and older community, you may have 80% of your residents who are vaccinated, and that'll help you in your decision making. So yes, you can do it, and it's not a bad idea to do it.
A question was asked, can you have, if there is an electronic registration process to use the pool or the facilities, can you have simply a checkoff with regard to waiver language, or should it be a separate document?
It should be a separate document, because when I went through the requirements that the courts look at, it has to be knowing, intelligent, and voluntary. And if it's just like a check off on another document, the main purpose of which is something else, you may not pass that test. So separate document, you want people to concentrate it. And while, you know, we're on that subject, I would make them as short and sweet as possible, because if, you know, I've seen waivers that are a couple of pages long, and the danger, and I'm not saying that this is absolutely going to happen, but the danger is the longer it is and the more legalese it looks like, the more a person can say, yeah, it wasn't knowing and voluntary. I didn't realize that was in there. So we keep ours to a page. We fit it on a page. It's, you know, obviously a full page, and we try to keep it as simple and straightforward as possible.
Caroline, you were going to ask whether or not volunteer residents can be pool ambassadors, weren't you?
Yes, I was.
I thought so.
It was circled.
And there's there's nothing in the regulations that says that can happen, but we would not recommend that. First of all, what volunteer in your community is going to agree to take on that responsibility when they could get sued if it turns out that somebody gets sick and it was because the pool ambassador wasn't doing their job?
Okay, there have been several questions asking us to discuss a little bit. So the association requires waivers and there is tort immunity, but a lawsuit is filed and against the association and or board members. Are board members required to pay out of pocket to defend themselves when something like this happens?
Most governing documents have a provision in there that the board members are protected. And so unless, again, we come down to that, gross negligence and willful wanton conduct, if you're not following the rules, it could be said that, that's the type of conduct, and then you would not be protected. And, the association could say, we're not going to pay for them. You didn't follow the rules, and so they wouldn't be protected. But generally, the board members would be protected and would be
If there's a determination of indemnification, it would be paid for in advance by the board. It wouldn't be reimbursing per se the board member.
right.
We have some follow-up questions about if an association or board decides to require the wearing of masks on the common elements or common property. Should there be signs posted? How do we recommend that go into effect?
Well, that's a minimum. I mean, having signs posted with all these requirements, keep 6 feet of distance and wear masks and all of that, they should be posted. And if you go into any business establishment these days, you're going to see 6 feet, stay 6 feet apart, and masking and all that. You have to make a reasonable effort to enforce as you open facilities, especially. This is going to involve some supervision. As I said, you can't just turn the key and open the door. And even though ambassadors are only strictly required in the pool context by the guidelines, and you may not need to call it ambassador, but you will need to have some kind of supervision over the facility so that you can say, oh yeah, we had a person roving through the building. We were aware of what was happening at all times. Because I can easily see a claim for gross negligence if you allow some club or committee to meet in a given room and they go over the number of people, they don't wear masks, they don't distance, they don't follow any of the rules, and then you have a claim. You can't just say, yeah, well, we didn't know they did that, because it's in your facility. You have an obligation to maintain control over that facility. And so I wouldn't just let that kind of thing happen.
We have a question. Can you allow one waiver per household for everyone in the household, or should waivers be signed by each individual?
Each individual.
Okay.
I mean,
If
you can have one with 2 signature lines on it, but everybody has to sign.
Okay. If one of the rules is that you have to be vaccinated in order to utilize the facility, do you still need a social ambassador or a pool ambassador?
Yeah, I would think so.
Yeah, I mean,
You know,
who's going to, supervise? As I just finished saying, you got to maintain some kind of control over your facility. So whether you put a star on somebody's identification for the association or require a CDC card, you need to know that the person has been vaccinated.
it's a Department of Health regulation. There's no exception that says that if people are vaccinated, you don't need to do that.
Right. That's true.
We have a question that if an association wants to offer one of their facility as a vaccine site, what do we think about that?
The phrase vaccine was used, so I guess that's for me.
Yes.
I just have a general concern about opening up facilities to the public generally because of other issues as well, which, you may have just, ADA kind of related issues on, opening a clubhouse up for the public. So that would be one of my concerns, at least.
What if it's limited to the residents only?
For an issue, and it's not open to the public. But if you're opening up as a vaccine center, I envision it being open to the public.
If you were,
We've been approached by some of the counties to ask if some of our facilities would make themselves available for vaccinations. And like Ron says, if it's limited to just the residents of that community, and if the state will step in and say, we will take liability for anybody who, for instance, gets sick while getting the vaccination, then I don't see that there's any reason why an association shouldn't offer themselves up like that.
But if you open up to the public, you can be deemed to be a place of public accommodation for handicap accessibility.
And that's not a good idea. That's right, Ken.
Okay, well, since it's approaching 1:30, it is 1:30, and we know how much everyone wants to get back to work. We did receive a lot of questions as far as whether or not this presentation is going to be generally available. If someone was not able to make it today, will we show it again? Will we make it available? Are the slides going to be made available to those who attended? So I defer to those who make those decisions.
Yeah, our plan is certainly to post something. We may edit it a little bit, but something's going to be posted so that folks can revisit.
Thank you all for attending. We appreciate it, and we are all available to answer any additional questions that you think of. And I apologize if I wasn't able to get to your question, but as we said at the beginning, please consult with your own attorney for further information. We wish you all continued health and good luck, and enjoy the rest of the day.